Reprise au débat. The honourable member for Saanich Gulf Islands.
Thank you, Madam Speaker. And it's an honour to rise in this place to put my views forward following the member for Abitibi Bay, James Nunavik, EU. He certainly said exactly in much clearer, more passionate language and with a greater depth of experience the reasons that I am also putting forward amendments to try to repair Bill S-3 so that it does not perpetuate gender-based discrimination against Indigenous women and their descendants. So this bill, S-3, comes to us, as members know, as a result of yet another court case raising the issue of discrimination under the Indian Act. Now, let's just step back for a moment and acknowledge the Indian Act itself is a monument to discrimination. The Indian Act itself is a racist piece of legislation, and I grieve that we are not, as a parliament, taking on that challenge of eliminating the specter of a piece of legislation. I think many Canadians may not know this, that it was the piece of legislation on which South Africa modeled apartheid. It needs to be replaced, it needs to be gone, but what we have before us is a slice of that discrimination that is embedded in a discriminatory act which treats Indigenous women and their descendants quite differently than it treats Indigenous men. The case was brought to the Quebec court by Stéphane Deschanel. The court set a deadline. The case was heard and resolved in 2015. The deadline was extended once, and as you've just heard in the comments from my honourable colleague in response to a question, just today the plaintiff returned to court to ask if Madam Judge Mass would extend that deadline once again. As the deadline now sits, this Parliament needs to resolve the matter by July 3rd, or there will be consequences in the issuance of status cards. There'll be unacceptable consequences. On the other hand, it's certainly distressing and incomprehensible to me that, given how flawed this bill is, that the minister, that the government of Canada hasn't gone to the court to ask for an extension. Should we be able in this place now to accept either my amendment or the amendment put forward by the honourable member from Abitibi Bay, James Nunavik, EU, if we accept those amendments, then at least we have a piece of legislation which doesn't perpetuate gender discrimination. If we accept those amendments and the government feels, it creates a tremendous chaos out there. We're not sure where we're going to go next, and they don't want to move forward with legislation. All they have to do is go to that judge and ask for an extension. The Quebec court in this matter has made it very clear, as of less than an hour ago when the press conference from the plaintiffs took place, we now know that the judge has said she remains ready and willing to give an extension. She wasn't willing to give an extension on the deadline today on an application from the plaintiff because she didn't want to put the Quebec Superior Court in a position of arbitrating between the Senate of Canada and the House of Commons. But it's very clear, very fresh and pertinent and timely information that that extension could be had if the government seeks it. I would wish the government would seek it. But let's go back to why these amendments really matter. It is a question of justice, it's a question of discrimination, and it's a question of whether we can draw a line in the sand and say, well, all the historical wrongs that happened if someone was a descendant based on relationships before 1951, we're just going to say that doesn't matter anymore, and we're going to limit it to 35,000 people because that's a manageable number. This is something I've never seen before in any debate on rights. We can only give fairness to X number of people. We're not prepared to extend it to all the people. It's unconscionable. I want to go back, and my colleague has already mentioned the testimony of Professor Pam Palmater, who is, I think, uniquely qualified in this debate, not only because she's a distinguished lawyer and professor and comes from the territory of the Mi'kmaq First Nation in Nova Scotia, but she's written a book which directly bears on this. Her book is Beyond Blood, Rethinking Indigenous Identity and Belonging. So that her research has shown, for example, that you can, I'll quote her, that the hierarchy of Indian status between Section 6.1 and 6 sub 2 have and continue, and that refers to sections of the Indian Act, have and continue to disproportionately impact Indigenous women and their descendants since its creation in 1985. It is an unconscionable formula based on racist ideas related to blood quantum that were designed to legislate Indians out of existence. She goes on to say, as a result, Canada's own demographer can pinpoint with relative accuracy the extinction dates of each First Nation in Canada based on birth, death, and out-marriage rates, close quotes. Some might wonder what out-marriage means. The essence of this discrimination is that if a First Nations man marries a non-Indigenous woman, their children continue to be recognized as Indians for purpose of the Indian Act. If a First Nations woman marries a non-Indigenous man, the children are not recognized. Further, children of unwed mothers, mothers who are not willing or able to name the father, or fathers who deny paternity, you go through a whole hierarchy of subtractions. Subtraction of Indigenous women's rights through a hierarchy of different classes of peoples. Now, if our amendments, my amendment or the amendments put forward by the NDP are accepted, we could restore at least those pieces of S-3 that were put forward in the Senate and are strongly supported by a number of senators. Well, they were supported by the Senate and removed from this bill by the government. They're the thing that make it possible to support S-3 and get it through this House. With those removed, we're back in a situation where the defense that I hear from the government is there'll be simply too many people. We won't know quite how many there are. As I said, this can't be a question of numbers. Again, from evidence that was heard in the Senate committee, if the estimate is there will be 200,000 people instead of 35,000 people who now have rights through ancestry and parenthood once the historic discrimination against women is removed, well, that's roughly equivalent to the number of new immigrants we take into Canada every year. 200,000 as a number needs to be put in some context. Why would we deny rights based on the fact or the question mark that this might be too many new people? The fundamental crying need in this area of law is to get rid of the Indian Act. And then we could be talking about how do we move forward from here. But we are dealing only with this piece based on the court decision and the court case brought by Stéphane Deschanel. It doesn't seem to me we have any choice other than to actually eliminate gender-based discrimination. I want to turn again in the roughly minute that I have for the words of Professor Pam Palmater, because I think it couldn't be clearer. Quote, "There is no reason to consult on whether to abide by the law of gender equality. The laws of our traditional nations, Canada, and the international community are clear on gender equality. There is no optioning out of equality, nor can it be negotiated away. Traditional Indigenous nations did not permit inequality between genders. Constitutionally protected Aboriginal right to determine one's own citizens is conditioned on Section 35(4)'s guarantee of equality for Indigenous men and women." And of course, that's 35(4) of the Canadian Constitution. "The United Nations Declaration on the Rights of Indigenous Peoples provides extensive protections for Indigenous peoples and also guarantees these rights equally between Indigenous men and women." And I want to underscore this sentence from Professor Palmater's testimony. There is simply no legal mechanism by which to consult out of gender equality. Discrimination is discrimination, whether 5 layers of discrimination are piled up on us or only, and she put only in quotes, 1 layer. Indigenous women and our descendants bear an unfair burden of trying to convince others it should end. Madam Speaker, I urge every member of this House to vote for the amendments here, and then we can pass S3 with a clear conscience. Thank you.